Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book from the Legal Action Group. It's the Access to Justice charity. They produce very, very important books for us as practitioners, and this one is the newest one in the series. It's called Youth Justice, Law and Practice, and it's been written by three people: Kate Aubrey-Johnson, Shauneen, Lambe and Jennifer Twite. Elizabeth was the lead writer on this review, and we had a long discussion about the book, and we came up with this title for our book review: An Invaluable Resource for All Professionals Working in the Youth Justice System. That's what you're getting. It's very much the house style of LAG, and I'm very pleased with the book. There's the front of it anyway. You can see the front. There is the spine. You can just read that, you can see that bit there and then that. Then you probably can't make too much out on the back cover, but that's the back cover. It's a heavy book. It runs to 850 pages. The back of the book has an index. The index is by paragraph numbering, which is the house style for LAG publications. It should be pretty easy to find things. There's the front cover there. Then you've got some information about the Legal Action Group. Those are the authors, information about them. Then it's also available, of course, as an e-book, which you'll see the details of there. I'm afraid I'm a bit old-fashioned in that I like the main book as well. The e-books are useful, but the difficulty is comparing one page with another. That's one of the problems with the e-book, whereas I like to be able to flip between the pages. There's the front page there. Then after that you've got some detail about LAG. Then you've got a dedication. Now that dedication is important. We only review books we think are important for practitioners and academics. I don't review books that I don't think highly of. This is a very good book and a lot of people are involved in it. So this is the dedication, which we'd always like to show. Then there's a foreword from David Ormerod, who will be known to many of you as the local ombudsman. And you've got, in fact, he's Law Commissioner now for England and Wales. The preface is there, running through from the three authors, dated March 2019. And then you've got the contents section running all the way through. Detailed contents. Then after that, you've got some case law. Then after that, you've got some statutes, as usual. A lot of information then. Then after that you've got a table of statutory instruments, of course, because there's an awful lot of information. Then the European stuff, that's European and international legislation. It'll be with us, Brexit or no Brexit. It's important because there's always an interface with the European side of the matter. Now there's also a very useful abbreviations part, which is helpful because there are a lot of abbreviations. It's so easy to forget something. You just have a slight mind fade or whatever you want to call it. It's very easy to do. So it's useful to have the abbreviations. Then we get into the book itself. There's the beginning. Children in the criminal justice system. You've got the standard house style. You've got an index for the chapter. Then after that, so you should find things. You've got some key points blocked out, which you'll be able to find. Then you've got the paragraph number. You can probably see it. Paragraph number is at the side there. Then you've got, of course, footnotes as well, just running through. You can see how it operates in the middle of the book. You can see a shaded portion of the book at the end. Now that shaded portion is where the annexes are. And what I'm doing, I'm just getting to there. Appendix A is there. It's the Youth Court Protocol. And then after that you've got various other appendices, all connected. These are criminal practice directions. Then you've got Appendix D is sentencing children and young people, and then you've got the sentencing, the actual people and young people, the sentencing part of the book, which is in a slightly different shaded position there. It's what are called the overarching principles. And then after that you've got sexual offence guidelines as well, a very important growing area, alas. And robbery guidelines, you can see there, if I can just show that to you. As I say, I don't want to bend the book out of shape, but you've got a lot of quite detailed information, which within the criminal justice process is very specific to youth crime. Obviously you've got things such as the various steps in terms of personal mitigation. So I think from many points of view, this book will be very helpful for counsel involved and solicitors, of course, involved in any matters concerning youth justice. And certainly when it comes to things like mitigation, there are some important points that one might like to bear in mind concerning advocacy. So what do we say about the book itself? Well, once again, Legal Action Group have produced a legal text on youth justice that is both authoritative and accessible to a wide readership, from judges and lawyers to all professionals involved in any capacity with the youth justice system. And of course, it's a special part of the criminal justice process as a whole, and it does take, in this day and age, its specialist. And that's one of the reasons why this book is very useful, because depending on what your practice is, it may well be that you would need to have a little bit of a refresher on exactly where we are with law and practice in this area. And this is what the book does for us, because the three authors offer an impressive body of expertise and special insight into what is an often fraught and more than usually sensitive area of law. I deal with children, but it's under the Children Act in family law matters, and I don't do criminal work any longer. But these are specialist areas which it takes a certain approach, as it does with the sexual offences as well. It's a certain approach that has to be adopted. And of course, what the authors have done, and LAG have done, is they've created a legal text of some 900 pages, which, far from being unwieldy, and you saw me balancing a little bit, is reassuringly navigable and handy to use, about much more later. Can I just say it's very much the house style, so if you're familiar with LAG publications, you'll know how they are structured. In the meantime, the authors' remarks about why they've produced this book are worth noting. And certainly worth quoting, and this is the quote: "We have written this book," they explain, "because we believe that every child, including those in the criminal justice system, deserves the best possible legal representation, represented by lawyers who are specially trained and knowledgeable about the particular needs of their clients." And that is exactly what the position is, because I think in the future we are going to find much more specialism in this area, and probably there will be a requirement for additional qualifications. Certainly at the moment that hasn't really happened, but I'm someone who comes as a lawyer with a PGCE because I've taught special education children, needs children, and I understand the difficulties, and of course there are lots of safeguarding requirements which we have certainly within the family court structure, and I think this is going to certainly become very much more important and an overarching principle in the future. We hope, say the authors, that this book will be used by solicitors and barristers, judges and magistrates, youth offending teams and social workers, police officers and other professionals, parents, guardians, but most of all we've written this book for the benefit of children, to ensure children are not treated in the same way as adults in the criminal justice system, and that they are diverted from the criminal justice system wherever possible. Now, I understand that some people don't like that policy, but I think it's the right policy, and I'm certainly, having been involved in this in the past within the criminal jurisdiction, I can see that that makes absolute sense, because the whole purpose is not to criminalise and label people if we can possibly avoid it, and that, I think, is the right policy. The word rehabilitation, which we don't possibly hear sometimes as much as we should do, should very well be there, because just remember how many people in this age group, it's not really discussed here, how many of them have been excluded from school, how many of them have had a very difficult time under SEN or whatever it might be, and they therefore need some assistance. Now, as the Law Commissioner for England and Wales says, David Ormrod, Queen's Counsel, he wrote the foreword, he supports this view to the hilt, insisting that children should be treated entirely different to adults, and he's absolutely right, pointing out that the youth court system has evolved from the more familiar adult one. He adds that this unfortunate reality ignores the numerous significant differences that exist. But I think it's important to note nonetheless that there are several principles which make the youth justice system distinct from the adult criminal justice system, which this book of course clearly explains. And I think that distinction whatever one views culpability and the criminal intent and the behaviour sometimes of some of the clients, you know what you're dealing with, but you've got to realise, as I certainly have as a teacher of young adults, the 16 to 19 group, it's a difficult age and you've got to understand where they're coming from. I know some people don't like that, but that's the way it is. And I'm not changing, and neither is anyone else, because that is exactly why we need books of this sort and this high quality for good reasonable cost from LAG. Also explained at some length is the age at which a young person can be considered a child, and the age at which a young person can be considered criminally responsible. Another controversial area. It is stated unequivocally that the criminal age of responsibility in England and Wales is 10 years old. Now, I say that because at the moment, even as I'm recording this, that is under review, because it depends on what you're reading as to exactly where we are. So please treat a little bit of this with a certain amount of understandable knowledge about where the changes may occur, because this matter, say the lawyers, is a particularly low age in comparison to many other European countries, where across Europe the average age of criminal responsibility is 14. It's also mentioned that the UN Committee on the Rights of the Child has criticised the United Kingdom for keeping the age of criminal responsibility unjustifiably low. And as I write this and as I say this, I believe that there are changes which are going to take place. However, that's on the basis that this book in its current form is looking at the standard common law concept of dolly in capax at 10 years. So therefore, it may well be that there will be changes. So do bear that in mind. Matters relating then to age and age assessments are an important but relatively small part of what is a formidably broad range of material presented in this book, which covers children as victims and witnesses as well as suspects and defendants, and includes a range of reference materials that includes videos, animations, DVDs and the like. The final section of the book deals with the sentencing and criminal records, and of course there's much more besides, and that's why the bit right at the back, the appendices, will be very helpful, I think, for professionals and practitioners. I think the judiciary will find this helpful too. Most courts I go into have the LAG books, and that is a testament to why they're so good. And the judiciary, I know, use them extensively, because obviously some of them, as judges, write them. So that makes some sense, doesn't it? Busy practitioners, therefore, we think will appreciate the extensive section containing tables of cases, statutes, SIs and the European and international legislation. Obviously that's with us, come what may, with our relationship with people in Europe. And that means that it's there and it's going to stay there. Also, you'll find very useful the 3-page table of abbreviations, which I highlighted at the beginning, because that again, you can suddenly think, well, what does that mean? Because you can have it could mean that or that. So if you go to the abbreviations, that will help. You've got the 4 appendices, including the youth court protocol, which I think will be helpful. It would be entirely fair then to say that this book should be considered an essential reference for any professional dealing with difficult issues, with these difficult issues involved. So every lawyer, in our view, involved in child-related matters concerning, this is youth justice law and practice, in other words the criminal justice process, should have a copy of the book. And the date of publication of the paperback itself is cited as at the 24th of April. Let's just have one last look at it. There it is again. It's a heavy book. There's the spine and then there's the back. And as I say, you can see the shaded area, which gives you the protocols and the appendices at the back. Opening it up in the middle, let's go to, this is chapter 14, anonymity. You can see again, I'm not going to open it up too widely, you can see the index of the chapter at the front, paragraph numbering, turning to the age of 18 and what happens then the blocked out bit, which gives you the key points, then the introduction about children appearing in court, and obviously the standard view at the moment about the need for anonymity. Now I say that because obviously that's very important in the youth courts. It's also important with everything I do in the civil world with family law, because again there are a very substantial number of people who want us to open up these secret courts to journalists and so forth. With great respect, that isn't the way to deal with it at all. These matters, generally speaking, we're not trying to hide things, we are trying to protect the people involved. Because frankly, if the information does eventually come out, it will come out at a later stage, quite often on appeal, as I have found when I've gone from the lower courts to the higher courts, because that's suddenly when journalists become more interested. But I do think the protections have to remain, and I, like many of my colleagues, will fight to keep it that way for the time being. We're not hiding things, I make that very clear, but there has to be this level of anonymity to protect people, and it's understandable. On that note, thank you, LAG, and thank you to everybody concerned for maintaining the high standards you do and giving us such help. It is greatly appreciated. Thank you. Bye-bye.